Okay. Good morning, everybody. My name is Peter Hoffman. I'm the co-chair of Garfunkel Wild's Compliance and White Collar Defense Group. And thank you for participating in today's webinar, Home Care Referrals, Marketing, and the Kickback Laws. Today's webinar is broken down into 4 sections. First, we'll take a look at some of the laws, rules, and requirements that apply to marketing in the home care context. Second, we'll identify some potential issues for you to be aware of as you move through these issues on a daily basis. Third, we'll talk about some real-world examples of government enforcement in this area, particularly recent examples. Fourth, and finally, we'll cover some practical considerations or things for you to think about as you grapple with these issues in your business on a day-to-day basis. So let's get started with the laws, rules, and requirements that you need to be aware of. One of the first laws to consider is the Federal Civil Monetary Penalties Law. In particular, there's a provision under this law that deals with beneficiary inducements. This law prohibits the offer or transfer of remuneration to anyone who's eligible for benefits under Medicare or state health care program, which includes Medicaid, that you know or should know is likely to influence the individual to order or receive from a particular provider or supplier an item or service that's payable either in whole or in part under Medicare or a state health care program. And again, for today's purposes, state health care programs include things like Medicaid, of course. Under this provision of the law, there's a specific definition of remuneration. And the law defines remuneration to include transfers of items or services for free or other than at fair market value. However, the OIG, who enforces the Civil Monetary Penalties Law, has carved out inexpensive gifts of nominal value. And the term nominal, for purposes of the Civil Monetary Penalties Law, has a specific definition. Nominal means a retail value of no more than $15 per item in an individual instance, or $75 in the aggregate per patient on an annual basis. Cash and cash equivalents are carved out of this. What's interesting here is we have a definition of nominal value that, as we'll see later, is somewhat different than the definition of nominal value when you're in the context of an MLTC plan. Violations of the Civil Monetary Penalties Law can result in substantial penalties, both monetary penalties, assessments of up to 3 times the amount claimed for the services submitted to Medicare or Medicaid or state health care program, and of course, exclusion from your federal health care programs. Exclusion, of course, as you know, often acts as a death knell to providers in the business. A second law that you need to be aware of when analyzing your marketing relationships is the federal Anti-Kickback statute. Now, unlike the Civil Monetary Penalties Law, the Anti-Kickback statute is actually a criminal statute, and it makes it a crime to knowingly and willfully either solicit or receive or offer or pay any remuneration, whether that's done directly, indirectly, overtly, or covertly, in cash or in kind, either in return for or to induce referrals for federal health care program business. Again, the best examples being Medicare and Medicaid, or for the purchasing, leasing, ordering, or arranging for or recommending anything that is payable under a federal health care program. So what is remuneration under this statute? Well, the statute does have a very specific definition. Under the Anti-Kickback Law, remuneration specifically includes kickbacks, bribes, rebates, whether they're given directly or indirectly, overtly or covertly, in cash or in kind. But really, as the case law on the AKS has developed over the years, remuneration can be virtually anything of value. Cash and cash equivalents are remuneration, gift items, some of the things we've seen and we'll talk about during this presentation. For instance, our concert or sports tickets, vacations. Remuneration can also be above fair market value payments or the giving of free services to referral sources, to beneficiaries, to potential patients. So remuneration under the AKS is very, very broadly interpreted. Importantly, under the federal anti-kickback statute, courts have held that the law applies to any arrangement where just one purpose of the remuneration was to obtain money for referrals or to induce further referrals. Now, what does that mean? That means, if you think about marketing, you can have 4 or 5 different purposes to a particular arrangement. If 3 or 4 of them are wholly legitimate business purposes that no one would question, but one purpose is to pay or receive money in return for or to induce referrals, the law is implicated and can be violated. And that means that both sides of a kickback arrangement are potentially liable. That's the payer of the kickback as well as the recipient. If you were to expand that to the home care universe, that's the home care agency as well as whoever is receiving the remuneration in return for referrals. Penalties here are also quite extensive. Now, I said it was a criminal offense, which it is, but your consequences for violating the AKS can be both criminal, civil, as well as administrative. And what that means is, under the statute itself, it's a felony. That means a very serious crime and carries a sentence of jail of up to 10 years, as well as a fine of up to $100,000 for each kickback act, or both. You can also have administrative penalties. Those are issued by the OIG under their separate authorities for violations of the kickback laws. And currently, the OIG's authority is also a maximum of $100,000 for each act that violates the kickback law. And of course, exclusion from federal health care programs can and will result from kickback violations. Again, almost virtually a certainty to be a death knell to the agency's practice. What's more, the law under the False Claims Act was recently amended so that claims that are for items and services that come from a kickback, in other words, you pay a kickback and you get referrals which are then submitted, for instance, to the Medicare program, they constitute a violation of yet another law, which we've all heard of, called the False Claims Act. The penalties here are quite severe. They're civil penalties. They include treble damages, which is 3 times the amount of damages to the government, plus per claim penalties, which were recently upgraded from what the statute requires. The minimum per claim penalty is now $11,000 and change, and the maximum is more than $22,000 for each individual claim. So the consequences, you can see, are quite severe. Now, because the reach of the anti-kickback law is so broad, the statute itself has certain exceptions, But the government has also established some regulations called safe harbors. And these safe harbors protect certain specific types of arrangements where the potential for abusive practices has been deemed by the government to be minimal. Safe harbors, to apply, must meet all of the relevant safe harbor requirements in order to guarantee protection. If you don't meet all the requirements of an applicable safe harbor, the government will typically look at the totality of the circumstances to determine whether there's a violation of the law. In particular, they will look at what the intent of the parties was in entering into and carrying out the relationship. But also, they'll look at a variety of factors, and these come up all the time when you talk to the OIG and when you look at their issuances. They'll look at overutilization. They'll look at whether the arrangement results in increased costs to Medicare or Medicaid or other federal programs. They'll look at whether the arrangement may result in corrupted medical decision-making. In other words, is the physician who's making the referral or whoever's making the referral using their independent medical judgment, or are they or could they be being influenced by the remuneration they're receiving? Patient steering, unfair competition, these are the things that the government typically looks at. So you'll want to be aware of that. Now, when we bring it back to marketing activities, in home care in particular, there are certain safe harbors that may apply to your marketing arrangements. And in particular, there's a safe harbor and a statutory exception for employees. And there's a second safe harbor that covers personal services and management contracts. Generally, this will cover your relationships with 1099s or independent contractors. Let's start with the employee safe harbor because it's important to know, and it's actually quite interesting. This safe harbor actually has two prongs to it under the Anti-Kickback law. Remuneration under the Anti-Kickback statute will not include, one, any amount that is paid by an employer to an employee who has a bona fide employment relationship with the employer. Now, what does that mean? A bona fide employment relationship under this law means that it is a true employer-employee relationship as defined by the IRS. The second prong, and this is where it gets a bit interesting in the context of marketing, is that the remuneration has to be for the employment in the furnishing of items or services that are paid for by federal healthcare programs. What that means is the remuneration has to be for employment in the furnishing of covered items or services. Now, there's also a parallel statutory exception. Essentially, it has the same two prongs. Why this safe harbor and exception is so interesting is that many courts and the OIG have said that the safe harbor will not protect payments to employees that are made solely for directing referrals. And that to qualify, the compensation that's being paid by the employer to the employee has to be tied in some way to the provision of federal healthcare program covered items or services. In other words, to meet this safe harbor, you have to meet both prongs. It has to be a legitimate, bona fide employer-employee relationship, and at least in part, it needs to be related to the provision by the employee of covered items or services. Let's talk about an example. In a recent case out of Florida last year, the AIDS Healthcare Foundation made a $100 bonus payment to each of their employee, quote, linkage coordinators, marketers, for every referred patient who completed certain follow-up procedures at the foundation's own clinics. The services provided were in turn billed to the Ryan White program, which is a federal healthcare program. Now, in the false claims context that this case arose in, the court said, hey, the employee exemption under the safe harbor applies. And so this was a good relationship. And a lot of lawyers and those in the compliance field took this to mean, hey, if you have a true bona fide employer-employee relationship, even though you're paying bonuses that appear to be directly related to referrals, that you're going to be okay. There's also some 25, 27-year-old commentary by the OIG that can be read to suggest the same thing. But when you look at this case a little closer, you'll see that under the Ryan White grant, under the program, the term referrals was actually defined to mean covered services, or to include covered services. So this case is not quite what it appears. It is not quite helpful to the home care world that many think that it may be. Here's a better example. A second case, also out of Florida, as I recall, involved a drug treatment program. And they established a relationship with two government workers who worked in the field of drug addiction and had access to a lot of patients who needed access to drug treatment programs. The program arranged with these two workers to pay $250 every time they referred a patient to the drug treatment program. At first, the payments were being made by company check and were signed by the program owner. He was saying, these are my employees. I believe he was saying they were part-time employees for us, even though they were working for the government. But later on in the relationship, the payments were made a bit more sketchy. Either in the parking lot, in cash, your more prototypical brown paper envelope cash payments. Well, the court took a look at it and they said, look, I get your argument that these were bona fide employees and therefore the safe harbor applies, but these payments, these $250 payments were purely for referrals and were not for any legitimate services that were being provided by the workers that Medicare would reimburse for. In other words, not for covered services. And by the way, the court said no one in their right mind is going to believe that these government workers were in fact bona fide employees of the program as well. So the employment safe harbor is something to look at. It's valuable. There is some dispute about its reach, but it is something that when you're dealing with marketing personnel and marketing arrangements, you should be considering. A second safe harbor covers personal services and management contracts. This is really going to be used for your 1099 relationships, your independent contractor relationships. And under this safe harbor, remuneration will not include payments by a principal, usually in our case a home care agency, to an agent, perhaps a marketing rep, as compensation. But it has 7 standards. And remember, for safe harbors to apply, all of the standards must be squarely met. So let's walk through those standards pretty quickly. First, you need a written agreement, and it has to be signed by the parties. Second, the term needs to be at least 1 year. Third, the agreement has to cover all of the services to be provided by the agent to the principal, and they have to be specified in the agreement. Specified, not generally services that we'll decide upon later, not broad terms like marketing things like that, you need to specify the services. Fourth, and this often trips up some of our clients in the context of marketing relationships. If the services are to be provided periodically, sporadically, part-time by the agent, the contract needs to set forth the exact schedule, what their length is, and what the charge is very clearly in the agreement. Now, when you have somebody working part-time, they may be doing work for other entities, maybe marketing for other entities. Our experience is that it's very hard to pin down that someone's going to work for ABC Home Care Company from 12 to 4 on Wednesdays. That doesn't seem to be how it works, but yet it's necessary to meet this safe harbor. Fifth, another stumbling block in the marketing world. The aggregate compensation has to be set in advance. It has to be fair market value. It can't be based on the volume or value of referrals or business generated between the parties that is payable under a federal health care program. Now, there's a lot in there. What that means, some buzz terms here: set in advance, aggregate amount. What that means is no percentage arrangements. A percentage arrangement will not meet this safe harbor. So be cognizant of that. Sixth, the services can involve the counseling or promotion of activities that violate federal or state law. This is kind of tricky because kickbacks violate both federal and state law, so it's something to be aware of. And finally, the aggregate services can't exceed what's necessary to accomplish the commercially reasonable purpose of the services. So you can't pay more than fair market value for the services that are actually being rendered. Now, because the statute, the anti-kickback statute, is so broad, providers and entities have an opportunity to go to the OIG and ask for an advisory opinion saying, hey, we're going to enter into this relationship. We want to make sure that you won't impose sanctions or penalties against us. The opinion process is binding on only the requester, and third parties like us in the legal community are not supposed to rely on them. But the practical reality is that they often provide a good window into the OIG's thought process and how they may treat certain types of arrangements. In the context of marketing, OIG has been issuing advisory opinions for more than 20 years. So I wanted to point out a few of them that may be helpful to your process. One of the first ones is OIG Advisory Opinion 98-4. That was issued back in 98. Here you had a proposed arrangement between a management company and a physician practice who were looking to form a clinic. And the management company was going to do the typical management services, but it was also going to do marketing. And the way they were going to get paid was on a percentage of the clinic's net revenue. So if you think about the personal services safe harbor we just talked about, you'll realize pretty quickly that you're outside safe harbor, because the payment methodology is going to take into account percentages. And that means the compensation is not set in advance. The compensation is not aggregate. The real reason I always go back to this AO, this opinion, is because the OIG reiterated something they had first said way back in 1991 when the safe harbors were issued. And they say, it's here in bold on your slide: we believe that many marketing and advertising activities may at least involve technical violations of the anti-kickback law. And in this case, they said, we're not approving this arrangement. We think it may involve prohibited remuneration, primarily because the percentage payments and the marketing combined to raise the level of concern of improperly increased patient referrals. Now, there are some more recent advisory opinions in 2006 in the home care context. The OIG issued a very interesting opinion. Here are the facts. The requester was a nationwide network of home health care agencies that provided home health aides, personal care aides, home medical equipment. And what they wanted to do was to provide Medicare and Medicaid beneficiaries who were scheduled for surgery with a free pre-op home safety assessment, which was not covered by Medicare or Medicaid. The assessment would be done by a physical therapist, either over the phone or in the patient's home. The physical therapist was an employee of the home care agency. The surgeon or the scheduler who was scheduling the surgery would recommend during the scheduling process that the home care company come in and do this pre-op assessment. And the patient had no obligation to use the home care company for their post-surgery surgical needs. Now, the OIG didn't like this arrangement. They said free services, free in-home pre-op safety assessments would be likely to generate referrals that were payable under Medicare and Medicaid. And this arrangement, of course, potentially violated the provisions we were talking about earlier, the CMPL, the AKS. And so they said, don't do this. Just about a year later, in 2007, they were asked about another relationship or another arrangement. In this one, a home health agency was providing prospective orthopedic patients with free, there's that word again, educational videos that had instructions for them about how they should best go about their post-operative home care convalescence. In this one, unlike in the prior one, the OIG determined, well, we will not take action under our authorities for this one. But they realized, having just issued the year before the home safety assessment decision, that they had to distinguish the two outcomes. And here's what they said and why the pre-op home safety assessments were different. Here in this case, the videos being offered weren't personalized. The information could be found on the internet. I don't think Google was as prevalent, but you could certainly go back and find things on the internet in 2007, relatively easily. And with the preoperative assessment that they did not like, in that case, the physical therapist who worked for the home care provider was going to the home or at least talking to the patient and, in the OIG's view, giving the impression that the patient was getting a valuable service that was important in the context of their surgical outcomes. And because of these personal relationships, the OIG thought that in that case, you had a situation where the service was likely to influence the patient to select the provider as their provider of post-op home health care needs. If all these laws, federal civil monetary penalty, anti-kickback, were not enough, many of us are in New York State, doing business in New York State. New York State has its own set of anti-kickback laws, and they're quite similar to the federal law. Generally speaking, they prohibit a Medicaid provider or someone acting in concert with a provider from soliciting, receiving, accepting, agreeing to receive or accept, or offering or giving anything, payment consideration, for referrals for Medicaid business or for purchasing, leasing, ordering Medicaid business as well. The one good thing here is that New York's law has built into it, if you meet an exception or a safe harbor, employee safe harbor, personal services safe harbor that we talked about, under the federal law, you're going to be okay under the state laws as well. So that's a good thing. It makes the analysis and structuring of arrangements a bit simpler. Penalties here are also quite severe. Jail time, depending on the value of the property, fines of up to $10,000. You can have real assessments if you're gaining money or property due to or through the kickbacks, fines up to double the amount of your gain. And of course, you can get both a fine and imprisonment. So these are real laws to be considered. Now, in New York, of course, when you're dealing with long-term care, there are a number of MLTC plans. And as you likely know, the New York State Department of Health has a set of marketing guidelines that are applicable to the MLTC plans and to providers. I'm not going to go into detail on all those rules, but they do also touch upon improper inducements. And specifically, they touch upon inducements to the patients, to the beneficiaries, or to how the beneficiaries are obtained for enrollment. So providers and plans under the MLTC policy are prohibited from offering, quote, material or financial gain, close quote, to Medicaid beneficiaries to induce them to parole. So what does that mean? That means providers and plans can only make reference in their marketing materials, which of course have to be approved by DOH, to the services and benefits that are offered under the program. In terms of gifts, and this is a little bit interesting, the state says only gifts of a nominal value, meaning a fair market value of no more than $5, and offering those gifts regardless of the beneficiary's intent to enroll. Now compare that to the OIG's definition of nominal that we discussed earlier, which was $15 in an individual instance and $75. This is far more restricted. So if you're in the MLTC world and you're dealing with MLTC patients, in terms of offering nominal gifts to be okay to enrollees, the limit is substantially less than the OIG under the civil monetary penalties law. In addition, under MLTC policy, providers may not pay any individual, nor can they accept payment from a plan of commissions or bonuses or something similar that's based on numbers or Medicaid eligible persons who are enrolled in the plan as a factor in determining compensation. No counting. And of course, beyond the scope of what we're doing today, due to time constraints, there are a variety of other rules depending on the context in which you're operating. There are Medicaid managed care program rules. There are Medicare Advantage rules. CMS has communications and marketing guidelines that talk about a variety of issues. So you really need to be aware of what context you're operating in and what are the specific rules in those contexts. And here, for instance, if you look at the partial capitation contract, there are specific restrictions that DOH imposes, and those restrictions by contract apply both to the plans that the state is contracting with and to the participating providers that the plan is contracting with. So very similar to what we just talked about, no monetary incentives to Medicaid recipients to join plans, the $5 limit on nominal gifts have to be made available to everyone, no discrimination, regardless of the intent to enroll. Nor can the plans offer financial incentives to marketing reps based on numbers. Cannot do it. Okay, so that's a lot of laws, rules, and regulations, and really we could have gone on forever about that. But there are a whole bunch of potential issues that I want to discuss. OIG has been talking about this for 20 years. Recently, in 2016, they issued a new OIG alert regarding home health agency, criminal convictions that they've garnered, civil settlements that they've obtained in cases that touch on marketing, because they deal with things about payments for referrals, which sometimes the agency couches as marketing. They deal with obtaining false certifications for patients as being homebound. And of course, medically unnecessary services or services not rendered. The concerns the OIG has is really the same thing we touched upon earlier: medical judgment, patient steering, overutilization, increased cost to Medicare, Medicaid, and other programs, unfair competition. Those are their go-to concerns. You want to look at any proposed arrangement that doesn't fit squarely in a safe harbor or is otherwise compliant through the prism of these types of issues, because this is what OIG will look at. And the government did warn, and we found this to in fact be the case, that they are stepping up enforcement. So what are the potential issues? My view is there's a variety of potential kickback issues in home care, and they're often exacerbated by improperly trying to disguise them as, quote, marketing relationships. So what are you asking yourself? What do you need to be asking yourself in terms of your marketing activities and your marketing relationships? Well, what are your referral relationships? Are they with physicians? Are they with hospitals? Are they with nursing homes? Are they with assisted living facilities? And how is the marketing being done? One big area of focus, of course, has been on physicians. Physicians sign certifications. What are they doing in terms of new patients, in terms of the acuity of the illness of the patients that they're sending for home care? Do the patients really qualify for the home health benefit? Are they homebound? Do they need skilled care or rehab services? Here's an example. A few years ago, the Seventh Circuit issued a decision that found that the physician had violated the anti-kickback law because he got paid in return for signing the 485s to both certify and recertify the need for services. Some telltale signs here: the payments were made in cash. The payments were based on the number and type of certifications. Certs got 400, the recerts 300. The home care company had also loaned this physician a substantial amount of money, and based on the referrals he was giving, they were giving incremental forgiveness to that loan. Now, what's fascinating here, and one of the reasons I've included it in the slides, is that there was no dispute in this case that all of the patients that were referred for home care needed the services, and they received the services, and they had already selected the provider of the services. Those are go-to defenses when you're looking at an accusation of payments for referrals. This court said, doesn't matter. The payments were solely for referrals. The indicia was there, and the physician wound up with an 8-month in jail sentence, community service, and forfeiting of the roughly $32,000 in kickbacks he had received. What other things do you need to be on the lookout for? So we talked about your physicians as referral sources. You're also likely getting referrals from hospitals. So what's your relationship there? Are you giving them free services? Are you giving them something that they're required to do by law or may already be doing? A classic example is discharge planning. That's a hospital service. Are you sticking in there someone, calling them a home care coordinator or liaison, and really they're slipping over into the discharge planning function? That's a potential kickback. What are your relationships with the facilities, nursing homes, assisted living facilities? Are you offering free or deeply discounted services? In our practice, we've seen a variety of these things: nurse consults, wellness days, duplicative services that the facility, again, is already required, with the goal of the agency being access to patients who, because of their demographics, are likely well on the road or, in fact, in need of home care services. So take a look at your marketing relationships. Now's the time to reassess them. Do you have contracts with hospitals for discharge planning or exclusive space? What are your relationships with your nursing homes? What are your relationships with the ALFs? And of course, direct marketing to patients. What are you offering them? Are you offering them things of value, housekeeping, meals? If they switch to a new plan or a new provider, are you targeting people who really don't need or perhaps don't qualify for the home health benefit? These are issues. So the categories are physicians and referral sources, hospitals, nursing homes, ALFs, independent marketing reps, and of course, the patients themselves. Let's turn, as we try to move somewhat quickly towards the end, as I'd like to leave questions, a few minutes for questions at the end, to recent government enforcement, because what I've found as I've gone through doing a number of webinars over the years is that these really hit home. These are sometimes viewed by clients as abstract principles and, well, my competitors are doing this and, quote, everybody's doing this. But the government enforcement is real. So let's take a look. Just this year, just a couple of months ago, a Houston physician was sentenced to 25 years in jail. He had to pay about $27 million in restitution. And the facts of this case was that the owner of a medical clinic and another co-defendant were selling the physician's medical orders and other necessary documents that the doctor had signed to home health agencies. And the government contended, and was proved at trial, that these orders were falsely certifying what the patient's medical conditions were and their need for services. In fact, the patients weren't even under the physician's care. It wasn't the PCP. Some of these patients weren't confined to the home. They weren't homebound. They were not eligible for Medicare home health benefits. And yet, the referrals came in, the bills went out, and Medicare paid roughly $17 million in false claims. Let's look again, let's bring the focus back to marketing, which is really what we're trying to focus on today. In 2015, a home health care company owner was indicted. He was alleged to pay kickbacks to one of his marketers to generate Medicare referrals, even though proof showed, according to the government, that some of the patients did not qualify for home care. The marketer was also indicted. Remember, both sides of a kickback are potentially liable. The indictment claimed that the home care owner and marketer signed contracts that fraudulently stated the marketer would be paid based on the number of hours that she worked. But in reality, according to the government, the deal really involved payments for a preset number of monthly referrals. Now, why do I focus on this one, several years old? It is not uncommon in investigations of home care companies and marketers for contracts to exist, for clients to say, my lawyers looked at this. The take-home point here is that the contracts are usually being designed to try to fit within one of the safe harbors: personal services, employee, so on and so forth. But the contracts alone are not enough. You need to meet all the requirements of the safe harbor, And additionally, most importantly, the contracts need to accurately reflect what's being done. If the contract is a sham, the government will key on to that right away and disregard it. And in fact, it will make the defendant's argument that they were trying to do the right thing even worse, because in my view, it shows a knowledge and awareness that you needed to do something, and yet what you were doing on paper did not match what you were doing in reality. Here's another one. A Florida home care agency paid just last year $1.5 million. The company and its owners settled the False Claims Act case that included allegations that it was making illegal per-patient payments to their marketers, who were 1099s. They weren't employees in this case. They were independent contractors, in return for referrals. Specifically, they were paying $1,000 to the marketers for the first 5 patients recruited each pay period, and then $500 per patient thereafter. The referrals came in, services were provided, claims were submitted to Medicare pursuant to the illegal, what the government called the illegal kickbacks. And of course, that, as we touched upon earlier, results in a false claim. What's interesting here is the complaint was filed by a whistleblower who had worked for the company for just 8 months, and it really touched on all the things that we're talking about in this presentation. It touched upon alleged kickbacks to the marketers to recruit patients based on that illegal per-patient compensation formula. It touched on kickbacks to the facilities, where there were a whole bunch of elderly residents, and the idea was the agency wanted exclusive access to the residents and recommendations for their home care services. What were those kickbacks? Well, free services, de facto activities, such as an activities director who ran bingo and raffles and birthday parties and arts and craft programs and recreational activities. So the free services were the kickback, not just your traditional cash or cash payments. This case also touched on Medicare beneficiary kickbacks, just straight out gifts, gift cards, TVs, waiver of copay obligations. So these are real things. These are real world examples that are happening in the world today. In addition to the false claims settlement, they also entered into a corporate integrity agreement. By now, I'm sure all of you on the line are familiar with that. It's a separate agreement with the OIG, very strict, very onerous as it's developed over the years, typically 5 years, and has a whole bunch of very strict requirements, some of which you see in the blue bubble to the right. But the real take home here is that these CIAs are very costly to the agency. They're time consuming. You usually have to appoint people who you have to hire an independent review organization, IRO. You have to expend time and energy of your employees that could be done elsewhere. It's a real cost, and sometimes underrated as such. More examples: telemarketers. 2017, convicted criminally after a trial on conspiracy and soliciting remuneration for referring Medicare patients. Here, the company was training its employees to do cold calls, which we know is a no-no for Medicare, and convinced them to accept home health services. After they agreed to do so, they were referring the patients to a bunch of different agencies out in Chicago that had agreed to pay for referrals. The owner here, 1 year in jail, about $600,000 in kickbacks had to be returned. Here's a good one, little light one as we get towards the end of the presentation. This was a False Claims Act case by a home health agency. settled for $16 million back in 2015. And in addition to billing Medicare for unnecessary and non-reimbursable services, the agency was alleged to have provided tickets and athletic events and concerts, and provided other things of value to the docs and other referral sources to induce or reward patients. And according to the prosecutor, I thought this was an interesting quote, the practice was so commonplace that physicians would actually affirmatively reach out to the home health company and ask for tickets to popular events such as the Kentucky Derby or Taylor Swift concerts. Now, you can make any kind of snarky remark you want about Taylor Swift concerts, but they are quite expensive, and I do have 2 young daughters, so I can vouch for that. The marketing employees were also instructed to deliver bottles of liquor, there's an example of a kickback, or other enticements to their referral sources as they wanted to get, quote, valuable Medicare referrals. Now there are some more. This is still going on. The beat goes on. This year, a patient recruiter / marketer admitted that she was getting illegal kickbacks from a Michigan home health care company just for referrals. Medicare had paid about $1.25 million for those services. And again, you had the situation where some of them weren't even eligible for the home health benefit. This case is ongoing. Sentencing is currently scheduled for May 30th. I'm going to skip over the last one. It's kind of interesting. It's not quite marketing. It's kind of quasi-marketing. It's a transportation provider as a referral source. You can look at that in the materials. What was interesting to me about that was that the transportation provider who was getting the kickbacks to bring the patients in as home care recipients was in fact the whistleblower, and he still got paid out, just reduced by the amount of kickbacks he had already received. So that's the law. That's some issues we want to look at, and that is some examples, real world examples and recent ones that highlight the importance of these issues to you in home care, whether you're a provider or a plan or an employee or an independent contractor. There's a lot of moving parts here. So what I'd like to do is spend the last couple of minutes giving you some practical consideration, or as I say, things to think about. This is not an inclusive list, but it may give you a framework of what am I doing? What should I be thinking about? What do I need to do? First, understand what rules you're operating under in terms of your referral and marketing relationships. There's a whole set of laws. We've touched upon some of them. The federal and New York State anti-kickback laws, the civil monetary penalties law for beneficiary inducements, and others as well. Are there contractual requirements? Am I under an MLTC contract? Am I a Medicare Advantage provider? Are there policies or guidelines issued by the DOH? CMS has marketing guidelines that they issue for Medicare Advantage and the prescription drug program. What are they? Do you know them? Are you abiding by them? Second, who is doing my marketing? Are they employees? Do they meet the IRS test for employees? Are they independent contractors? Do they meet the safe harbor? Are they working part-time? Do I know when they're working for me? Do you have a job description? Do you have a written contract? Third, what are you paying your marketers for? Are you paying them fair market value for the services they render? Are you paying them without regard to the volume or value of the services being provided? What are they doing? This goes back to the case law that we were talking about. Am I paying them solely for referrals? And what does that mean in terms of whether I am protected under the law. Do my marketers know the rules? What controls do you have in place? Do you have a compliance program? I think everyone on this call understands that in New York, Article 36 providers are required to have a compliance program for Medicaid purposes. Those who claim, order, or receive $500,000 in any 12 consecutive month period are also required to have a compliance program. And even if you may not be provided, which in our experience would be quite unusual in this field, you should have one. Does it include training and education so that, as I mentioned, the marketers know what they're supposed to be doing? Does it include auditing and monitoring so that you know that they are doing what they're supposed to be doing? And finally, do you know what they're actually doing? Not what the job description says, not what you've taught them in the training, but what are they doing in the field? Are they reaching out to physicians, and what are they talking about? Are they reaching out to hospitals, and what are they agreeing to? Are they reaching out to nursing homes or assisted living facilities or other referral sources? And how are they going about doing that? These are things that you need to be aware of. These are things that are quite important. And I hope this is giving you kind of an overview of some of the rules that apply and how complicated it may be. We do have a couple of minutes left. Let's see if there are any questions. A general question that I was going to answer: can we download and print the slides, and will we get a copy of the presentation? The answer to that is yes. We will be sending out an email in the next 48 hours to 72 hours. It will contain a link to the presentation. In addition, we post our webinars on our YouTube channel. That's a Garfunkel Wild YouTube channel. That will be done shortly, so you'll be able to hear my lovely voice and see the slides as well. So there's a couple of different fashions. And of course, my contact information is on the slides. If you reach out to me directly, I'd be happy to send you a copy of those materials. Can you submit questions after the presentation today? The answer is absolutely yes. We welcome them, and we hope that you will do so. I'm more than happy to take calls, answer emails, and speak to any of those listening. To the extent that we can help, we'd be delighted to do so. Is there a legal way to pay a bona fide employee marketing bonuses commensurate with the amount of business they bring in? Well, this gets into the area we were talking about. Remember, there is a view, and I think it is an intelligent view, that there are two prongs to the employee safe harbor. One of them is being a bona fide employee under the IRS rules. The second is that the payment has to have some relation to the provision of covered services. So if you're paying exclusively for referrals, there are many, including the OIG, that would take the position that that does not meet the safe harbor under the Anti-Kickback statute or the exception. And there are some courts that support that. What you want to do is look for payments that are tied to services that your marketers provide that are covered. And it also obviously depends on the full scope of services that those people are providing. A general question, I think I'll take one more as we're coming on the end here. What can we do for marketing? And that's, I think that's a tough question to answer on the webinar, what I've tried to get across today is that what you can do is a function of what rules you're operating under. Medicare, Medicaid business is a large part of home care generally. You have the rules we've talked about. Are you a contractor? Are you an MLTC plan? We have some plans on board today. Or are you a contractor to a plan? There are specific rules there. So if you go back and look at the slides, there are clearly some issues that you need to consider, and those are the type of things that getting good legal counsel, such as Garfunkel Wild, can guide you through. We're about a little past 1, and I know everyone has a busy schedule, so I'm going to thank you again for attending today. I hope it's been productive to you. We are available after the webinar by email. The materials will be made available. And with that, I thank you very much for your attendance, and we hope to see you very soon. Thank you and have a good day.